In this video, we're going to talk about how you can get your green card without your spouse's help. This is for those of you who may have started a process with your spouse, but it didn't work out, or you may have gotten the 2-year green card and then the relationship didn't work out, and you're thinking, well, what do I do next? Visit us at Swat&Vee channel with your questions to see how best we can help you out with your process. Please don't forget to subscribe if you're new to the channel. Let's start talking. Did your spouse already file for you? Perhaps they withdrew the petition because the marriage is over, or they lost confidence in the process. It was very hard and very long. They just gave up and don't want to be part of your process anymore. Or is there some other reason why they withdrew? Maybe an attorney advised them to withdraw, or was your case denied? It could have been denied because maybe the government didn't receive all the evidence that they needed to receive to prove bona fide marriage, or the government may have accused you of fraud or misrepresentation, or the government concluded that your marriage lacks validity. It's not a valid marriage because perhaps you are still married to someone back in your home country and they didn't give them the proper authenticated divorce decree, and it could have very well been denied for other reasons. Like, maybe you need a waiver. Maybe the government said you need the form I-601 waiver, or you need a J1 waiver, or there is being mispresentation or any other grounds of inadmissibility. They are saying you need to address those issues before we could approve your case. Now, the big question is this: are you guys still together? Are you still in dense bona fide marriage? Because if you are, you can maybe try again using professional help, because if your case was denied to begin with and you want to do a refiling, I always recommend that people get professional help for the second filing. You're going to need to address the issues that the government had with the first filing. So the second filing has to be approached very, very carefully. If you are still together and perhaps don't need a refile, maybe you just need to appeal the decision and fight it. If you have grounds to fight it, you are in removal. There are other things that you can consider as well, like prosecutorial discretion, an adjournment, or a motion to terminate your case. Work with a lawyer to strategize to figure out what the next step is. So what now if you are not together? What can you do? And this is the meat of it, the meat of what I want to share with you. What can you do if you're no longer together with your spouse? I would firstly want to know, well, what is the reason for the separation, because that does make me differentiate in terms of what you can do next. What was the reason for the separation? Was there abuse in the marriage? Was there extreme cruelty? What happened in the marriage? Because if so, then you can consider the 10-year green card filing on your own under VAWA, the Violence Against Women Act, which is opportunity for those who have been abused in their marriage to file for their green card on their own. If the reason for the separation has nothing to do with abuse or extreme cruelty, then it's over. You can't really take another step with violence, and you can't do anything. If your partner gets up and leaves you, abandons you, that's it, and the marriage is over. They don't like you or love you anymore, but there is no abuse, no cruelty in the marriage, then you cannot rely on the marriage to get a green card. What can you do if your spouse did file for you, it did result in a green card, and you have the 2-year green card, conditionally residency, and it's about to expire, or perhaps it has already expired, and the marriage is over? Marriage is over because of divorce or abuse or cruelty, or maybe the death of a spouse. The marriage is over. Well, the good news is there is a way for you to get your green card through a process that allows you to explain to the government what the reason is, when it has to be one of those reasons that I just mentioned. But you could explain that and ask the government to consider your form I-751 petition as like a waiver, and have them consider it without the spouse. So you can reach out to a lawyer of your choice to help you out with that. If your form I-1751 petition has been denied after your spouse was gone, you could either do a refiling by getting professional help and building a stronger case to refile it. But if you are in removal, you have to bring that petition before the judge. It gets very tricky. Sometimes USCIS still has jurisdiction, and other times the judge has the jurisdiction. So definitely get professional help if you are in removal and you're thinking about the Form I-175 process. You could also argue that you will suffer extreme hardship if you have to go back to your country, and that could be a basis for your self-petitioning to get your green card. As you can see, there are so many things to consider. There are opportunities for people to do it on their own, and there may not be an opportunity for others to do it on their own. It really depends on your facts and your situation. I hope you guys found this video extremely helpful. If you know anybody that could benefit from this information, definitely make sure to share this video with them. We are all about empowering you with knowledge. So the more people that can benefit from this video, the more people we want watching this video. If you like this video, please make sure to hit the thumbs icon. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!